everybody. Thanks for joining us for this webinar on foreign direct investment in the US. We're going to wait just a few more seconds to give attendees a chance to connect. I know many of you signed up, which I think shows the significant interest surrounding this issue. As you may already know, the US has been the biggest recipient of FDI these past 2 decades, and now more than ever, thanks to the US labor shortage caused by the pandemic, there are greater opportunities that are available to corporate and individual investors that wish to enter this market. So in light of this exciting moment in time, I, along with my esteemed colleagues, Akshat Divatia and Jonathan Bench, we will talk through some of the key issues that foreign companies and individuals should consider in establishing a US presence. Specifically, Jonathan, who is one of our most experienced international attorneys and the chair of our corporate practice group, will talk about the legal framework of selling goods and services in the US. But he will also go over how to choose a business structure and how to protect your investment. Then we'll turn to Akshat, who is our lead immigration attorney, and he will provide an overview of the US immigration system with a particular emphasis on visas you should apply for. As for me, my name is Nathalie Bougenies. I'm a corporate and regulatory attorney with an international background, and I'll be your moderator today. But as the chair of the HEM practice group at Harris Bricken, I'll be available to answer any questions you might have regarding FDI in this particular space. So without further ado, let's start this conversation. Jonathan, can you talk to us about the main corporate issues you have worked on when helping clients establish a presence in the US?
Sure, and I'll give you a little background on some clients I've worked with recently. I call these my favorite clients because they come to us with little or no experience in the US market, and so they look to us as really as trusted advisors in helping them understand what the US market is like. So some of the first questions I get, I'll have on my slides, but the number one question I get is, where should we set up our business? And as you know, as business owners, this is a very complicated question, and it's got a complicated answer as well, because the US has 50 states, we have additional territories, we have different legal structures, and we have the federal regulatory structure on top of all of that. And so it can be very overwhelming. A lot of international people know about Delaware because Delaware is we call it a very business-friendly jurisdiction. And most of the public companies that are listed on US stock exchanges are Delaware companies. And most companies that are in the US that are trying to raise capital from venture capital firms, private equity, will also end up settling in Delaware. It's because the investors know what to expect. The board of directors and the officers know what to expect from a governance perspective. And so it gives a lot of certainty. And as you know, the business environment, especially in international business, it needs to be on a strong foundation of certainty. And so as you see things changing, I'll discuss geopolitical issues that have arisen. We know what's going on right now in Eastern Europe with Ukraine, and so all of us think about these issues quite a bit. We're not living them day to day because I'm not in Europe, but I know that the Europeans are in Europe, and I know that they're keeping a very close watch on that kind of situation. The Middle East has its own, Southeast Asia has its own issues, so the geopolitical concerns that lay on top of this always factor in. Now in the US, we tend to be pretty well settled. I know that sometimes international folks who I talk to want to understand what's going on in the US from a political perspective, what's happening, what laws are going to get passed, do laws ever get passed in the US? Those kind of questions, because I know what is on the international news about the United States. So back into where do we set up? Wyoming has risen as a popular alternative to Delaware because it has no state income tax. It's very pro-business. It's a very small state by population size. It's only about 500,000. And so the political will to get things done quickly has contributed to that. So if any of you are involved in Web3 businesses, cryptocurrency, NFTs, any DAOs, anything like that, Wyoming, you will hear Wyoming more and more in those industries. Nevada tends to be very popular as well because Nevada has low taxes, it has a great population base, it's very close to California, but it's not in California. And so you see a mixture. And I actually had an international friend ask me to explain the US response to COVID and how it works. And I described it based on coastal states versus inland states, more conservative versus more liberal states. And you really need someone who understands the nuances. And this all dovetails into what kind of business you're doing. If you're doing a business where Nathalie and I have worked on a client together from Switzerland that was coming to the US, and it was a hemp business, but even in the US, where hemp was legalized in 2018 federally, the states each have their opportunity to roll it out. And so it's not a clear-cut thing for by any standpoint. The bottom right of my screen, I'm leaving a choice, right? Because there are lots of inputs as business owners to figure out what US state do I want to be in. Am I looking for, if you're coming from Spain, if you're coming from Saudi Arabia, you may want a strong immigrant community that speaks your language, that understands your culture, that understands your values. And so my next slide, I'm going to show you a little bit of a demographic breakdown of the United States, because that often factors into business owners deciding where do we set up to hire employees that we like and that know us, and where do we go to sell to our optimal customer base as we're trying to get a foothold in the United States. And often a lot of companies that are outside the US have already been selling into the United States, and so they have a customer base, and that customer base may dictate where they set up in the US. So whether you have, whether you're looking for a large consumer market footprint, or whether you're looking for employees, or whether you need to be close to shipping ports, these will all factor in. Now, this was my favorite slide to put together for this presentation, because I love maps and I love demographics, and I love foreigners, which is why I work in international business. So if we go around, let's start with California on the top left. California has the largest population of any US state. Even the minority languages that are spoken, you see I have at the bottom here, I've got Korean, Persian, Armenian, Arabic. All of those minority languages are spoken by I think over 50,000 people in the state. So, massive Spanish population, massive Chinese population, a lot of Filipinos speaking Tagalog, a lot of Vietnamese, and then all of these others that we would consider, well, they're a minority, but they're significant enough. I included them on there because I wanted all of you, wherever you are in the world, to be able to look and say, okay, of these 5 most populated United States, which of them have languages where we might have an affinity group? So Spanish, as you see, Spanish is overwhelmingly the number 2 language in the US. There are a lot of Chinese, Asian languages, and of course there are a lot of Europeans that have retained their language group and culture. And so you may, depending on where, and we have these slides available too, so you don't have to memorize this now, but there is an opportunity for you to connect your business needs with a community that you're comfortable with in the United States. Now, the second question I get after where do we set up our business is, what kind of business do we set up in the United States? Part 1 on the left talks about a direct entry. So in order to do business in the United States, you can sell from outside into the US without having to do any registration. That doesn't mean you won't have to report US tax, because you will probably need to report US tax depending on tax treaty situation. And I'm going to talk about tax treaties in a little bit. But we have what's called a direct entry. As a foreign company, you can directly register to do business in the United States without setting up a US entity. Most companies do not do that because you don't get the US liability. You don't get protection from the US liabilities. A lot of times when we set up a parent subsidiary structure, one company above the other, we do that because we want to keep the risks from each of these companies separate from each other. That's the same and especially true across international borders. So rather than doing a direct entry, most companies look at options 2 and 3, which is, do we form a corporation? Do we form a limited liability company in the United States? Now, this slide is a little bit busy, but I'll try and break it down for you because there's a lot of useful information here. As we go across the top, I talked about liability. If you have a business, and really I have never met a foreigner who is not concerned about this. So every international company that is coming to the United States is concerned, number 1, about US litigation. They know that the chance of getting sued is very strong, but they don't want to expose their parent company at home and all of those assets to a US judge, to the US legal system. So usually we do not advocate for the direct entry. We'll choose a C corporation or an LLC based on tax reasons. And I probably won't go into the deep tax reasons here, but as a shortcut, if you're a corporation, your corporation will pay the taxes in the US and then send the profits home. If you're an LLC, then the parent company at home has to recognize all of those US profits and deal with those. So it's very much a two-edged sword, right? You have to decide which of those you're more comfortable with. And I would say that 90%, maybe 95% of my international business clients choose to go with a C corporation rather than an LLC because of the taxation liability. Now, the nice thing about the United States, we're going down to minimum capital investment, is that there is no minimum capital investment in the United States. You can set up a company you don't have to capitalize it, you can set it up, and other than paying your legal fees and maybe your accounting fees initially, there is no other capital layout. So you can form a company in the United States for very, very cheap compared to other countries that have minimum capital requirements. On the third row down, foreign ownership, whether you're a C corporation or an LLC, you can have 100% foreign ownership. There is no requirement that you have any kind of domestic owners or even domestic officers or domestic directors. So you can have all of your leadership, all of your decision making back home, and just have employees in the United States. And that's very appealing to a lot of companies, especially when they're starting in the US. Now, income tax is going to be paid no matter what. I said we'll talk about tax treaties shortly because I have a nice map that I put together showing which countries have a tax treaty in place with the US. But as a shortcut, you will have to pay sales tax, which is the equivalent kind of a VAT tax in Europe and other parts of the world, and you will have to pay income tax. You have to at least recognize the income tax. The next to last item, the tax ID number, that is actually one of the hardest things. It's one of the longest pieces of this puzzle. This piece of the puzzle takes the longest to put in place. Let me put it that way. And so if you're a foreign company that has never come to the US before and you need to get a tax ID number, which you will if you want to do banking in the United States, then the time frame is stretched out. If someone comes to me and says, I want to form an entity in the US, how long will it take? I can usually form it in a matter of days, but getting the tax ID number is more complicated and often will take a matter of weeks, usually not months, but usually several weeks at least. I mentioned tax treaties. If you are watching this and you see the name of your country on here, then your nation has a tax treaty with the United States. There are not a lot of Middle Eastern countries here, a lot of Central Asia. I was surprised, I really am surprised every time I look at this list from the IRS, which countries we have treaties with and which we don't. And so as a workaround, you may want to think about forming an entity in an intermediary country. So if your country is not on this list, but your country is friendly with one of the countries that is on this list, then you may want to form a subsidiary in that country and then use that country as your springboard to get into the United States. Now, when we're talking about investment, you may have heard about this in 2018, this group called CFIUS, that's how this is pronounced, CFIUS. This is the Committee on Foreign Investment in the US. CFIUS became much more important. It had existed before, there were laws in place before to monitor foreign investment into the United States, but many people attribute this to China's increasing role on the world stage. And so this Committee on Foreign Investment in the US was enhanced, right? The budget was increased, the number of people on the committee and working for the committee in the Department of Treasury was increased. And the purpose of this is to monitor foreign investment into the United States. There are, it's not just China focused. So I know that a lot of you who may be watching say, well, this is because of the US-China trade war. This is because the US doesn't agree with the way that China is doing business around the world, and because of China's increasingly belligerent standpoint with the US. But and I would say that's absolutely true, right? There's certainly no question about that. But at the same time, the US is generally concerned about making sure that foreign investments that come to the United States are not causing US companies to deliver intellectual property, any other trade secrets when they shouldn't, and not just to China, to other countries too. So you'll be a little shocked when I show you the safe harbor country list, but that'll be coming up. So if you are, and really, when you're coming to the United States, you're going to do this one of two ways. You're either going to acquire a target or invest in a target company that already exists in the United States. I'm actually working on one of these right now with a company from Europe that is looking to acquire a certain type of manufacturer in the US. So you can do that by direct acquisition investment, or you can do a greenfields investment. And so I want to focus first on, and by greenfields investment, if you're not familiar with that, that is where you bring your own capital, your own intellectual property, your everything into the United States, and you're not relying on any competitors in the United States as a step up to get into the US market. So if you are a foreign company in the looking to invest in the United States, this can include real estate, and then this can include any kind of controlling or non-controlling interest. So any monetary investment into any kind of company in the US, it may need to be reported to this committee for review. Now, these, by way of controlling interests, we're talking about could be a stock purchase or an asset purchase or a merger. If it's not a controlling interest that you're purchasing, then it's even something as small as a 1% interest may still need to be disclosed. Real estate matters when it's nearby sensitive U.S. real estate. So you can picture U.S. government installations, military, anything like that. And there are certainly airfields. There are whole counties in the United States where foreign investors cannot purchase real estate. And there's a map, a very user-friendly map that you can look at, and I can point you to that if you want to email me afterward if you're curious about where these locations are in the United States. Last thing is, even if your investment doesn't result in you buying a controlling interest, but you get some extra perk in the investment, say that you're a private equity or venture capital group and you're a limited partner, but as a limited partner, you're able to put someone on the board of directors of a US company, or maybe you are able to enter into a management contract so that you can provide services to this company. That may also need to be disclosed. So the rule of thumb is, if you are looking to invest in the United States, talk to a lawyer who is familiar with these CFIUS requirements, and then we can decide whether or not you need to do that. And just in the last year and a half, I have helped an Indian company and a Chinese company go through this analysis. One of them we had to submit to CFIUS, and one we did not. So industries matter. When the committee is looking at the type of investment you want to make, if your business is in US critical technology, critical infrastructure, sensitive personal data, and I've given some examples here. So under critical technology, and there are lists for all of these, okay? So you don't have to worry about memorizing it, but the list is quite extensive as far as what the US government considers its critical technology, critical infrastructure, or sensitive personal data. So under critical technology, it could be something like wireless communications. And these are all actual examples, by the way. So I wanted to include this because this is not just China focused. This first example was a Singapore company. So wireless communications, semiconductors, of course, we know is very hot right now, especially since COVID has impacted the semiconductor supply chain quite a bit. Under critical infrastructure, think of this as the underlying communications infrastructure in the United States. So phone, internet, satellite, anything else that gets developed beyond that. And then personal data is things like healthcare information, sexual preference. So this is Grindr, was a social networking app, and also hotel software, because the US government did not want, this was a Chinese company that was looking to acquire a company in the US, did not want this Chinese company to have access to all of the data about where people were coming and going when they were staying in various hotels. So the ultimate question is, if we're looking to come to the US, I know what I want to do. I want to acquire a target. I've identified a good company. Do I need to declare this investment ahead of time? And the way this law is set up, either you figure out, the best case scenario is when you're in the LOI stage, when you're just sending NDAs back and forth, you're just having initial conversations, that's the best time to call your lawyer to find out, is this the type of transaction that needs to be declared? Is my investment in a US company need to be declared? Because that will push the time frame for the investment out. And I know business owners want to move quickly. And so this is not optimal, but it is entirely possible that when you find a company that you want to hire, or you want to buy, or want to invest in, that you will be able to call your lawyer, get an answer in a week, and then you will know either, yes, we have to extend the closing by 30 or 45 days, or maybe longer, or no, we think we're in a safe space, we shouldn't need to declare this. And so that's the analysis you need to do initially. Then once you've decided whether or not you need to declare, if you're going to declare, you can decide whether you want to do it on a declaration or a notice filing. And these are based on how important the business is and really the size of the transaction as well. So the risks of not going through with this is that there is no limit to what CFIUS can do. So even if a transaction happens now or happened 5 years ago, if it was not declared, if it was not approved by CFIUS and CFIUS has a problem with it later, it can force the parties to unwind. It can inject itself into the process and say, well, now we need a separate management company to deal with this so that the foreign company does not have access to certain technology or to certain management decisions. And the only safe harbor, the only safe countries from CFIUS's perspective are Canada, UK, and Australia. And if you're thinking about perhaps, say you're a company in Spain and you want to set up a UK subsidiary, and the UK subsidiary will do the investment, so you'll be a safe harbor country. CFIUS is still going to look all the way back through all of the chain of companies until it gets to individuals, right? And so it will not approve the transaction until you go through all of the company structure to the underlying beneficial owners. So as I mentioned, this last bullet point, the only safe harbor investments are greenfield investments. So like I said earlier, where you take your money, your infrastructure, your intellectual property, and come to the United States, rent real estate, buy real estate, and set it up. That's the safe harbor. So if you're trying to decide between acquiring a company and doing a greenfield investment in the US, this should factor into your analysis. I think I've got a couple minutes left to discuss this, and I think there are questions that are coming in too. So I'm happy to field questions at the end of this or after Akshat's turn to speak, because I want to make sure I give him enough time to speak. So final things to consider, there are always government incentives. When you're trying to decide which US state to set up in, there are a lot of states in the central corridor. We call them the Midwest or the upper Midwest or the West. Before you get to the coast, there are a lot of these states that are willing to offer pretty healthy government incentives, so tax breaks, the kinds of things that US companies, when they're looking abroad to try to decide where to do business, the kind of things that matter to them too, right? Do you get tax breaks? Do you get tax breaks for employee costs? Do you get subsidized real estate? Can you situate in a place where the real estate will be very, very cheap or free for a little while? There are all of these options. And so if you are a sizable company, if you have a pretty good brand already in your home country and you want to come to the United States, it's very good to get connected to each state will have an economic development office, and often an office focused on international trade. You will want to connect with the people in the state, and they will be able to tell you all about all the government incentives that are available to you as a foreign company coming to the United States. Second point down here, your employees matter. And I run into this quite a bit with companies that are in the US and outside. Many companies, before they hire employees, will hire independent contractors. And independent contractors are okay in the United States, but there are a lot of criteria that you need to fit for someone to be considered an independent contractor versus an employee. And so if you misclassify someone who should be an employee as an independent contractor, that can be very problematic for the employee, but especially for you as the employer. So it's often something that you can fix. It's not something that you need to stress about, but it is something that you need to pay attention to. If you have people, especially if it's a single individual and not a company that you're contracting with to provide services in the US, then often you will need to treat these people as employees and get your filing set up the right way. There will be tax withholdings, there will be employment insurance payments. All of this will need to happen if you have employees in the US. The US infrastructure, is the third point, is very important. If you're a services company and you're dependent on the internet, you may want to go somewhere to a state or a city where you have lightning fast internet. If you are a goods company, if you're a manufacturing company, you're going to be worried about having a strong employee base, talented workforce, depending on the type of manufacturing you're doing. And you're also going to want to have good infrastructure so that you can get your products from your manufacturing facilities to your customers. So considering the infrastructure is very important. Many things in the US are shipped by truck so you can get them anywhere, but it's not the most cost-effective way to ship goods either. Rail is very good, and the US continues to build out rails, including rails that are connected to coastal ports. There are also a lot of free trade zones close by ports. We even have free trade zones near inland ports, like we have in my home state of Utah. And then last year, intellectual property. This is something that we could spend a whole hour talking on, but your intellectual property should be at the forefront of your mind, especially if you think you're going to be able to take your very successful homegrown brand and bring it to the United States. I'm working through this right now with a Russian company that's coming to the States for the first time. And I'm not sure that the brand that they've been using in Russia and elsewhere in the world will be able to work for them in the United States. So just something to keep in mind, whether you're dealing with trademarks, whether you're dealing with your more science-focused IP like patents, it's all something to talk about in terms of what assets are you going to be using in the United States, what assets do you want to send to the United States and have owned by your subsidiary. And a lot of this matters. I often ask my clients, what is your 5 to 10 year plan for the company? Do you plan to come to the United States as part of a bigger plan so that you can then list on a public exchange and sell everything? Do you want to go public? You want to get US investment? And so these questions all matter to you and should be a part of the initial conversation you have with counsel when you decide to come to the United States. So I believe with that, I am ready.
That's great, Jonathan. Yeah,
okay, thanks,
I think
Madam.
we should move over and talk more about the immigration aspect of FDI. But first, before I give this platform to Akshat, I just want to remind our attendees that you can submit your questions during the presentation via the chat box. And also you can access the PowerPoint on the sidebar. It's available and downloadable in a PDF form. So Akshat, why don't you give us an overview of the main US visas? And can you tell us if and how the pandemic has affected visa processing? I mentioned the pandemic earlier, and I think that that's an interesting thing to discuss today.
Yes, thank you very much, Natalie. It's my pleasure to be here. Thanks everybody for joining. Let me start off by just mentioning who I am and what I do. I lead the immigration section here at Harris Bricken. I call myself a business attorney who helps employees and their families in their immigration and mobility needs. And you know what I'd like to do is essentially I'd like to kind of provide you with an overview of the, what this presentation will be about. And I'll get to your question, Natalie, because I think it's an excellent question. In some ways, I'll respond to it partially during my presentation. And then once I'm done with all of my slides, at that point, I think I can kind of give an overarching view of what the pandemic has meant. As far as the visa categories in the immigration system, we call it an alphabet soup of visas. They're from A to T, and you can think of them as being in two big buckets. The two biggest buckets are the family bucket and the business bucket. In the family bucket, you have visas for fiancés, for immediate relatives, and these are parents, spouses, and children under the age of 21 of US citizens. You have victims of trafficking and crime. And then you also have visas for individuals from those countries that do not have a large history of immigration to the US. So those are diversity visas. Our focus today is going to be on the business visas. And I've lumped in the students and exchange visitors in the business category as well, because the way that they're regulated by the immigration agencies is very similar to how a business would be regulated. So if a university is issuing I-20s to students to study in the US, well, that university is going to be treated like a business entity, and it will have regulatory criteria that it will need to comply with. From a structure perspective, I would say that, this presentation, rather than kind of list everything at you, I'd prefer to do it in the form of a case study. And the goal is that if you can see a real scenario or real individual and his background and his family, and then look at different scenarios as to what he may be contemplating, I think it gives you a little bit more substance than just throwing the laws at you. Before I get started on that, I do want to talk about the visitor visa, the B1 ESTA visits for business. And I get this question a lot, can I come to the US as a visitor and start working? And the answer to that question is a categorical no. The criteria for admission into the US, as it says here in the slide, the residence and employment outside the US, so you have to have ties outside the US. The visit has to be specific, it has to be short-term. While in the US, the visitor may not engage in any productive work. And certainly the fear there is that individuals will come in as visitors and supplant the jobs from US workers. And then lastly, the foreign national, the B1 visitor, cannot get compensated from any entity in the United States while in the US as a visitor. So what is permitted? Well, essentially, it involves negotiating contracts, meeting with business associates. You can participate in conferences and conventions, in meetings, and you can also evaluate the potential investment opportunities, scope out office space for a new investment. The idea being that you are, here on a limited mission, doing things in furtherance of something in the future where you will have visa status to be able to engage in activities. And I'll just mention, the mindset with which immigration authorities, whether it's the U.S. consulate or the port of entry, where the Customs and Border Protection determines whether a person can or cannot be admitted. The mindset that they use is that of a tailor from Hong Kong, and this is from a case in the 1950s where the tailor was sent by a company in Hong Kong to take the measurements of its customers. The visit was appropriate for B1 purposes because this individual, this tailor, was employed in Hong Kong. He was there for a very limited purpose. He was there to take measurements of the customers. Once he got the measurements, he would fax that information over to the company in Hong Kong. The suits would be made in Hong Kong, so the productive work would not take place in the US, it would take place in Hong Kong. And then the payment for those services would be made directly by the customers in the US to the company in Hong Kong. So even though that's an old case, it's often cited by the immigration authorities to say this is what is appropriate under B1 rules. Okay, so now let's jump in and meet our case study. And this is an individual that is made up. He's not real, but the profile very much fits many of the clients that I counsel and that I have worked on cases for. So I have tried to make this as real as possible. Let's learn a little bit about Paolo. He's 37 years old. He's a citizen of Italy. He lives in Milan. He is married. His wife is a professional. She's a microbiologist by training, and the couple has 2 children, 10 and 7. His educational profile shows that he has both an undergraduate and a graduate degree. He has a technical undergraduate bachelor's degree, and he has a master's in management, essentially, making him both well-versed in technical things and in management. And on the professional side, he's been a software engineer for various companies in Europe over the last 6 years. And then specifically in the last 5 years, so a total of 11 years of experience. In the last 5 years, he's been a senior manager at a software company in Milan, and he has experience in onshore and offshore projects and managing those projects. So what I'd like to do is kind of propose some scenarios, and I'll talk about what that would mean for Paolo and his family. So the first particular scenario is, let's say that Paolo's Italian company wants to open up a subsidiary in Austin, Texas. The company knows that the tech scene in Austin is a really good opportunity to enter and establish itself in the US market. It wants Paolo to transfer to the new office and then to help it grow by hiring local staff, engineers, sales staff, administrative staff, to grow the company's footprint in the US. And Paolo, of course, when he goes, he's open to the idea, but he'd also like his wife and children to accompany him. So in a situation like this, it requires planning and it requires some foresight, but the appropriate option here is an L1A intra-company transferee visa. This is a visa for essentially executives and multinational managers. The companies have to have a relationship. So the US company can be either the parent company or the subsidiary, or it can be an affiliate where they have a common ownership. And I see this structure quite often where you have a holding company in the Netherlands that owns both the European entity and the US entity. So that would make the Italian entity and the US entity affiliates for the purposes of L1. The visa allows for the individual to stay in the US for up to 7 years, and that's broken down by initially 1 year if it's a new office, which it will be in the case of Paolo. Initially, the visa is granted for 1 year, and the increments of 2 years that the visa can be extended for a total of 7 years. One great thing about this visa, unlike, let's say, the visitor visa or student visa or an exchange visitor visa, is that it recognizes dual intent, meaning that the individual does not have to say, oh, I'm definitely going back. I'm not going to stay in the US for a long time. I don't want to immigrate to the US. They don't have to say that. By recognizing dual intent, essentially, the individual is saying, currently I'm in the US as a non-immigrant, but I may change my mind in the future and I may apply for permanent residence. And in that connection also, it's also possible for the spouses and children to do the same and to get green cards as a result of this conversion that's possible from L1A to a green card. As non-immigrants, of course, the spouses and children are eligible both to study and if they want to work in the US. So it's a very flexible, very permissive visa. Now, let's say in another scenario, Paolo really decides to leave his company next year. He's not sure if he wants to stay in Europe, if he wants to come to the US. He has an offer from a leading company in Seattle. The company is willing to wait for him until next year, until he makes up his mind. And his wife and children are not going to come with him right away, but they will eventually want to come in once the academic year is completed in the children's schools. So under that particular scenario, the most common option I see is that of the H-1B specialty occupation visa. Now this requires the US company. Now keep in mind, this is not Paolo's company. This is a large company. This is an established US company. Will petition for a specialty occupation worker with the US Citizenship and Immigration Services. And that essentially means a specialty occupation is one where the position itself requires a bachelor's degree or higher, and the individual also has to have possessed that degree at the time that the petition is filed. So, let's say you have hypothetically a PhD visa, a PhD degree holder wants to come here and work as a mechanic in an auto shop. Well, that position will not qualify for H-1B purposes because even though the individual possesses at least a bachelor's degree, the job is not one where you can show that across the board, all mechanics in the US hold bachelor's degrees or their equivalent. So that's important to keep in mind. The other thing to keep in mind is that there is a lottery for this particular visa. It's a hugely popular visa category. And there can only be 65,000 new visas that can be issued every year. So, there's an additional 20,000 visas that is for individuals who are, who are graduates of US institutions and have at least a master's or higher degree. But Paolo will not qualify for that because both of his degrees, bachelor's and master's, are from Europe, are from Italy. So, so he would be put in the bucket along with 65,000 other applicants. And in fact, the demand for this particular visa is typically 3 or 4 times the supply. So it is truly a lottery in that sense. The employer registers the individual electronically the registrations are then, put into a lottery. And if the individual is selected, then the company is invited to petition for the individual within a 3-month window. Once the H-1B status is granted, the individual can hold that status for up to a total of 6 years, and it is in 3-year increments. So the initial H-1B will be for 3 years, and there will be 3 more years granted. And there's no limit as to the number of times a person can change companies once he or she obtains H-1B status in the US. So you could hypothetically have 100 different H-1Bs, but of course the cap is typically the 6 years. So within that 6-year period, Paulo might be able to change, multiple employers, and he would not, each time he does that, he would not be counted against the lottery. He would have been counted once, and then he's liberated from that particular cap in the future. Like the L1, the H-1B recognizes dual intent. There is the tool used most often by most employers is to test the labor market and to do a labor certification, essentially paving the way for the individual to get a green card. So dual intent is permitted, but unlike the L1, the spouses and children of H-1B visa holders, who are called H-4 visa holders, typically for people in Paulo's situation, they're not going to be able to get any work authorization in the US. There is an exception, it's a very limited, narrow exception for individuals born in India and China. And because the backlogs for people from those countries is much higher because of the per country caps that are imposed on immigration, spouses and children of Indian and Chinese H-1B visa holders can get work authorization in the future, depending on how many steps are completed in their overall green card process. So I'll leave it at that. There's a lot more to say, but I'm happy to entertain questions offline, or if we have time remaining at the end of this presentation of mine. All right, let's switch gears now, and let's talk about Paulo's entrepreneurial spirit. So let's say that he wants to leave his company, and instead of working for anyone, he wants to be at the heart of innovation in Silicon Valley. He wants to start his own company. He's going to team up with somebody who, who's a U.S. citizen, who's based in the U.S., and who can help contribute to the startup costs. And in that setting, Paulo will be the chief technical officer, and his friend will be the chief executive officer. And even if the friend did not want to be the chief executive officer, so long as Paulo maintains at least 50% control of the company, he would be eligible for the visa that I'm going to talk about in the next slide. So essentially, Paulo wants to come in, he wants to invest, he wants to grow, and he can, his family can come here as well. All right, so I want to be mindful of time. I'm going to quickly, talk about the E2 visa. It's based on treaties of friendship, commerce, and navigation between US and Italy, and there are many countries that have those treaties. There is substantial investment requirement. It has to be at least 50% equity by the foreign nationals. So Paulo has to have 50% equity in the company. He has to develop and direct the company, so he cannot just passively invest the funds. He has to be actively involved in the operation of the enterprise. The investment must be active, it must be at risk. The spouses and children are eligible to get work authorization and study in the US. So it is a permissible category in that sense. And then lastly, excuse me, the E2 allows for the individual to keep extending his E2 status indefinitely, but the criteria for E2 have to be met, meaning the company has to exist, the ownership equity has to be at least 50%. And as long as the company is profitable, E2s can be extended, but there is no mechanism automatically to convert E2 status into an immigrant visa. Okay, so skipping to the international entrepreneur rule, I'm not going to talk about. I'm going to mention the points here so that you can see them. They're in the handouts as well. This is a relatively new program. It was, initially proposed in 2017. It was supposed to be implemented at that time, but because of, litigation and political issues, it just wasn't put into effect until May of 2021. So it allows for individuals to invest smaller amounts or to get government grants, government awards, and invest in the U.S. and get a visa as a result of that. But because it doesn't permit spouses and children to also qualify for this automatically, kind of as dependents, it's not really a good option for Paulo. So his wife will have to do the same thing, and his children will have to do the same thing, independently qualify. So it does not work out for Paulo, but it would for some other investors who are single. Let's quickly talk about the fourth scenario. This is, let's say Paulo and his wife decide to, follow their passion, invest in a winery. They have their life savings, they want to invest. They find an up-and-coming winery in Sonoma Valley, and they want to, they want to manage the overall operations, but they want to hire professionals to run it on a day-to-day basis. So for them, the option is the EB-5 immigrant investor visa. Some of you may have heard about this. It is a controversial visa, and the slides mention a threshold amount of $900,000, but since then, the threshold amount has actually been lowered because of litigation. So the actual threshold amount right now is $500,000. It's essentially a 50% discount. They could invest in a rural area, kind of like what Jonathan mentioned about the companies being traced. The funds must also be lawful and traced all the way to their origin. So if you got a gift from somebody, then the funds would have to show how the person who gave that gift and how the person acquired the funds to give that gift also is really important before an EB-5 can be issued. The requirement also is that once you invest, you get a conditional green card, and then to remove the conditions within 2 years, you have to show that the entity created at least 10 full-time U.S. jobs. So that is a very quick rundown of the EB-5 and the E2, and I'll leave open some questions if we have time for them, and happy to see also talk offline.
Yeah, I think that's a good segue, Akshat. And we've been getting quite a few questions from the attendees. So maybe since we are on the immigration topic, let me ask you one immigration question. Are these some states that are more favorable for investors or entrepreneurs from an immigration perspective? Yeah, so I would say that the short answer to that question is no. Unlike what Jonathan shared, as far as some states and their setup makes it easier for new companies, the only requirement from an immigration perspective is that you have a profitable business. And so when you come to open up a company in the United States, you want to make sure that you will be able to grow, and you'll be able to hire the talent, and you'll be able to be profitable, because ultimately your ability to get the visa and then extend the visa really does depend on how legitimate you are. You may have a business plan and you may be given a visa based on a business plan, but then when you go to renew your visa, the U.S. government will compare your performance against that business plan and see if the metrics that you anticipated, were you able to comply with them or not. And this is a great way to, great point to talk about, how the pandemic has affected the immigration side of things, is that, companies that came out with the idea that they would be successful and they'd be profitable, they've had to kind of, push back their dreams of expansion in the U.S. because the pandemic has most definitely affected their ability to find talent, to retain talent, and of course, to sell their products. So until the pandemic is truly and fully done, I think that it's important for companies to kind of evaluate their options, line up the requirements, and strengthen their ability to enter the U.S. market, but be flexible as well. Great. All right. Well, I think since we have 10 minutes until the end of this webinar, we should really just focus on questions. And what I propose we do is go back and forth between corporate and immigration questions. So Jonathan, why don't you answer this next one? Can you tell us how difficult it is to set up a U.S. bank account?
Bank accounts are the bane of my existence. Whenever I try to explain to companies how the US banking system works, and of course, you know, the US has very strong anti-money laundering and compliance hurdles for the banks, it's very difficult. So what I found is that the big banks, you know, you're talking Chase Bank, US Bank, big international banks, they are only interested in you if they have an existing relationship with you, and if they know that the compliance hurdles that they will have to go through with your company will be worth it. So if you have substantial deposits, you have big cash flow coming through, then they may be willing to bank you in the United States. The other option is to go with smaller, what I consider boutique international banks. These are banks that are they're small. Some of them are online only, but they have a very strong ability to research. They have partners abroad, and so they can do the anti-money laundering and know your customer compliance research very well. So that's what I found, is that the big banks really don't want you unless you're a big fish, and the smaller banks, most of the regional small banks in the United States, smaller and regional banks in the United States, won't bank you because they don't understand your business. They don't know where you come from. They don't have resources in your home country to understand who you are. And so you have to find it's this very small sweet spot of banks who will work with them, work with companies coming from abroad. The other thing to consider is that the banking takes a little while, right? Remember I mentioned that getting a US tax ID number often takes quite a while when you're an international company, and you can't open a US bank account until you have a tax ID number for your new entity. So it can be problematic. It's often the longest piece of the formation puzzle. And so it's not something that you should leave to the last minute. Certainly, if you think you're going to be able to come to the United States and start doing business after a week or two, it is most likely not going to happen. And the banking will be your big hurdle.
Great, thanks for that. Akshat, we got a question about whether or not it's a wise idea to come to the US as a visitor and then apply for a work or an investment visa. What are your thoughts on that?
Yeah, that is also a great question. The answer to that is, generally no. It might be legally possible, but practically speaking, it creates a lot of hurdles. And the main reason is that when a person comes in as a visitor and does not disclose the intention to change status down the road, officers at the time that they do apply for a change of status will look and try and see if there were any signs that show that shortly after entry into the US, the individual did things that show that the intent was something different than what was manifested at the port of entry. So practically speaking, it results in officers kind of scrutinizing the case, looking for ways to deny that case. And most importantly, when you come on an ESTA, which is the travel permission that most Europeans qualify for, you get a maximum of 90 days. And if you come in from any other country that requires a B1 visa, then you're given up to 6 months. But in the first 90 days, any actions taken that show that you either enrolled in school, or you set up the company, or you put your kids in a preschool or a daycare, or enrolled them somehow, that would show that you had the intent to stay here for a longer time. So those actions, even though you're not actually applying in those first 90 days, those actions show your intention, and officers can use that to deny the visa. It's much safer to return after that temporary trip, to do things right, apply for the visa at the consulate, and then come in lawfully in a status that allows for work.
Great, thanks for that, Akshat. We have a few more minutes for questions. Jonathan, the next question pertains to other service providers besides attorneys. Can you give us a list of the providers that foreign clients should connect with in order to enter this market?
Yes. Whenever I work with international companies, I always ask them first if they have a CPA, an accounting firm that they're working with. If they have an accounting firm at home that they're working with that does international work and has an office in the US or some familiarity with US laws, or they understand the implications of the tax treaties between the home country and the US, then I will ask them to put me in contact with the CPA right away, so that we can make sure the structure we're setting up in the US fits the company's model, fits what needs to happen. Like I said before, we may have to form a company in an intermediary country, and then decide to use that to come into the United States. So Your accountant is your best friend. I like to consider that your lawyer is your second best friend when you're a business owner, but your accountant is always your best friend. Other than that, bankers are always helpful. If you're looking to acquire real estate or even to rent real estate, you'll want to find a good real estate agency that you can work with. And then also the development. I mean, I would say if you have a web presence, which most companies do these days, then you want to get in contact with a good US marketing company that understands how to do business in the States. And if you're doing e-commerce, that's an extra burden on top of it. Even if you do e-commerce very well at home, it's going to be a different model in the United States, in large part because of the 50 different states and their taxes that you need to be paying depending on where you're selling products or services. And then the last person's probably, let's say we covered marketing, real estate, probably an employment agency, right? If you're looking for employees, you haven't identified them yet, you may want a headhunting firm looking for talented people for you, or you may just want to make sure that your first hire is the absolute right person to help you to do, the technical setup of your business in the U.S., but also to help recruit and train new employees. So it's a whole suite of people. I also mentioned government agencies. If you know where you want to go because you have a good reason, like I had a company that was an outdoor company, and they had identified Montana as a desirable place because Montana is a very rugged Western state, and the Montana governor was very interested in helping them come to Montana. So as early as you can get plugged into the international trade centers in those states, or at least talking to someone like your attorney or your accountant who might have those connections, those are all very good places to start depending on exactly what your business model is going to be.
If I could add something to what Jonathan said, if we have time, from an immigration perspective, it does matter how you capitalize the company. So you may have, very minimal capitalization requirements from an entity structure perspective and setup, but for your ability to then transfer employees to the U.S., it does depend on how serious you are. You don't want to send in a whole bunch of executive chefs if you don't have a restaurant, if you don't have the staff that's going to be the, sous chefs, dishwashers, et cetera. You want to be able to have presence and be doing business in the U.S. before you decide to transfer that individual over. So, companies that are here for the long haul, recognize that those are investments in the true sense of the word. They have to be made, because without that, the company is not likely to be found credible by the immigration authorities to say, look, we're going to go out on a limb and give you a visa for 1 year. But, what is the promise? Show us that you're going to put the money and you're going to grow the entity so that you can end up paying the particular salary and that you're going to be here for the long haul.
And speaking of investment, we have time for one last question. And one of our attendees is wondering if you can take a loan to apply for an investment visa.
Yeah, that is not a common question, but in the EB-5 context, it comes up a lot. It applies both in E2 and EB-5 context. Generally speaking, yes, there's no restriction on the loan that can be taken. What does happen is that the officers, whether it's at the consulate or at the U.S. Citizenship and Immigration Services, what they want to make sure is that the loan is secured by the investor's personal assets. It cannot be secured by the business. Let's say, for example, you can't have a loan in the name of a new company in the U.S. And then use those funds to transfer to the U.S. You have to have those funds essentially tied to you personally, so that if things go sour, you're going to be personally liable. And so that's kind of the reason why most individuals, if they're going to do a loan structure, we are involved. We want to make sure that the banks or whoever the lending institutions are recognize that it has to be the personal assets of the investor. So loans possible, but attached to personal assets.
All right. Well, we are at the hour mark, which means that we have to end this webinar, but thank you everybody for attending. And just as a reminder, the recording of this webinar will be available in a few days on the HB, the Canada Law blog. So if you want to rewatch this, or if you know someone who's interested in watching who couldn't attend today, then let them know that they can do so in a few days. All right. We'll see you later. Bye-bye.
Thanks, everybody.
Thank you.